My Lords, I'm conscious of the time, so I've stripped back some of the points of the cases I was going to take you to now, because in a sense they're more reply cases anyway. Those cases, which I think are more cases relied on by my learned friend, are Sprite Brand and Charlie Record. If I can put it this way, more his cases than mine. So I'll deal with those cases in my reply, but we have set out our argument on them at some length in our written case. What I do want to do is just mention the performing rights case, Mr. Justice Norse's decision in Whisky Distillers, where he adopts the Canadian test in Wentmore, and then go to the Australian authority, which we rely on in our case, in support of the proposition, essentially, that where you are acting in the execution of your duties, and properly so, the act is the act of the company, and it is not yours. Conversely, if you act outside your duties, or wrongfully and so forth, then the act is yours. That is the principle which we essentially seek to advance. Can I just deal first of all with the performing rights case very briefly? Because although I submit Lord Buckmaster's dictum, which I took you to, is capable of more than one interpretation, you can see how you might read it either way. In the Performing Rights Society case, Lord Justice Atkin interpreted to me effectively any act done by a director is which causes a company to commit a tort of strict liability, well, he's liable as well. That's broadly what it comes down to. And he translates, essentially, what is said by Lord Buckmaster. I submit that is wrong. First of all, he misunderstood Lord Buckmaster. But secondly, and perhaps most importantly of all, the performing rights case had nothing to do with the problem. It was a case about where a band had played Colonel Bogey in breach of copyright at the theatres, at the theatre, and then so the Performing Rights Society go after the theatre company and also Mr. Faraday, its managing director, who was on holiday at the time, and he basically said, I couldn't care less about all this. And anyway, he goes flying down at first instance. Mr. Judge takes a rather dim view of Mr. Faraday's behaviour, no doubt. But anyway, he appeals to the Court of Appeal and says, I had nothing to do with all this. I mean, I didn't even know about it. Not very surprisingly, his counsellor stopped almost immediately. So the point doesn't go because, of course, the Court of Appeal said, well, yes, of course you're not now. That's it. But it's in the context of that that Lord Justice Atkin, so to speak, expands on Lord Buckmaster's dictum. I say there being no argument from counsel at all about it. It seems to have been given the next day, the judgment. It is not a judgment which should, however much respect one gives to Lord Justice Atkin, is not the sort of judgment which can carry much weight. Although it is quite clear that subsequently it has. It's standard to see Raymond Chemicals and Performing Rights Society taken in tandem as establishing the principle against which I argue. What I want to do next is to go to the White Horse Distilleries case, which is a decision of Mr. Justice Norse, which is at E4531. This was a passing off case, and it was decided shortly after Wentmore, and again a director was sued along with his company, or two directors were, and the test which, and Mr. Donald Nichols QC was appearing for the defendants, so they had every reason to say Wentmore's wrong. But anyway, Mr. Donald Nichols QC thought otherwise, and he was prepared to go along with the Wentmore test. Now, you may say, so what? I say, well, it does go some way to showing that this is there's some respectable pedigree, but also, more importantly, Mr. Justice Norse's judgment, and he initially deals with the point about director's liability, but from E4560 onwards, but more importantly, at E456135, line 35, to 4562, line 12, he sets out what he understands the principle to be. He slightly restates the Wentmore principle, but you can see, first of all, I think E4561, if my computer is on the same page, he refers to the Wentmore decision. At the, I think it's 4561. Sorry, it's 455.
It is, but you're taking it from line 38? You?
Yes, I think so, my lord, forgive me. My computer is slightly playing up on the pages. I can't move it around. Here we are. it should be page 90 at the top. I turn now to the final page, so it should be 4560. He starts the consideration of the question at 4560, as I said.
Yes.
I turn now to the final question, and then he refers to Mentmore, a patent infringement case, and then he goes on to recite at line 45 from Mr. Justice Leday's decision, and you will see, if I can ask you just to read 45 down to on the next page, 4561, line 47. And it's in particular on the passage at 4561 at line 36 to 47. And I particularly rely on, at 42, it is unnecessary for him to know, or have the means of knowing, that the act or conduct is tortious. It is enough if he knows or ought to know that it is likely to be tortious. That he puts forward as the test. It is enough if he knows or ought to know that it is likely to be tortious. The facts of each case must be broadly considered in order to see whether, as a matter of policy, and answerability for tortious acts, they call for the director to be held liable. And then he continues with the final paragraph on that page, not necessary to consider whether this is the position in England, because Mr. Nichols conceded the point. But he does then go on to say, and I obviously adopt this, in 4562, second line, subject to the question of policy, there is, in my view, much to be said for the higher test, particularly in regard to its requirement that the director should make the act or conduct his own, as distinct from that of the company. That would seem to be an entirely rational basis for personal liability. Conversely, it would seem to be irrational that there should be personal liability merely because the director expressly or impliedly directs or procures the commission of the tortious act or conduct. In the extreme but familiar example of the one-man company, that would go near to imposing personal liability in every case. As for deliberateness or recklessness and knowledge or means of knowledge that the act or conduct is likely to be tortious, I think that these may on examination be found to be no more than characteristic, perhaps essential, elements of the director's making the act or conduct his own. And then, up to this point, I respectfully think the Mentmore test, as I've answered it, correctly represents the law of England. The introduction of considerations of policy, which I take to be capable of overriding the basic principles of liability, in a particular case is more difficult, and I doubt they have any place in our law. So in other words, Mr. Justice North prefers a strict test by reference to foreseeability, rather than some sort of weighing up of policy considerations. My Lords, I submit that is an entirely rational basis for liability.
Applying that higher test, I beg your pardon,
Yes.
He finds Mr. Joyner to be personally liable.
Yes, because he knew perfectly well what he was doing. And then there was another, he was closely involved and was, he can't remember off the top of my head, but he certainly knew what he was up to. He wasn't able to say, well, I did it, but I didn't realise that was the effect of it. Mr. Justice Laws finds that he knew what he was doing. I'll come to it if I can find the reference later, but that's certainly what he did. The other director, he says, wasn't even involved in the first place.
Yeah.
So that's how the matter was resolved. as far as, if I can now come to just, I think, one other authority in England I just want to refer to, that's at 2391, paragraph 77. This is a recent decision of the Court of Appeal here, in the case of Barclays and Watt, at 2391, paragraph 77. And this was a case, I think, involving negligence, an accusation of negligence against the director. The Court of Appeal found that, or the judge below and the Court of Appeal found that the director had not contracted a duty of care so as to be liable in negligence in the first place. Then the appellant said, oh well, he nonetheless should be held liable on an accessory basis. And I just want to show you what I think it's Lord Justice Mayo said, at paragraph 77, in relation to that argument. This is in the context of Williams, the House of Lords decision of Williams, which itself can turn on the question of liability for negligent misstatements by directors, negligent misstatements. But in paragraph 77, I do submit there is an important paragraph. In my judgment, such a conclusion, namely that Mr. Ioannou should not be held liable in negligence on an accessory basis, is also in accordance with the principles that accessory liability ought to be kept within reasonable bounds, and that it should be possible to carry on business by means of a limited liability company without exposing the individuals carrying on that business to personal liability. It does not offend against the principle that a person should be liable for his own tort, because Mr. Ioannou, who did not have personal dealings with the claimants or assume any responsibility towards them, did not himself commit a tort. Now, that I accept is in a different type of case, but the basic point I submit is important, that one should be careful not to extend the doctrine of accessory liability to cases where the director has acted perfectly properly and in accordance with his duties to the company. And now, you might say, how do I get there? Well, it's the answer I gave this morning. You didn't like the first one, but the other one, which I'm hoping is still in the running, the other one, there is no jointness in the enterprise. And what I would like to do is to just take you briefly to the decision in Keller. Now, we have referred in our written case to the various authorities at paragraphs 127 to 131 in Australia. Now, it's fair to say that they don't always speak with exactly the same voice, but broadly speaking, the weight is in favour of the Mentmore test, or an adaptation of the Mentmore test. And these authorities most certainly have considered this point in some considerable detail. And the one which considers it perhaps in most detail is the decision in Keller. Now, there are three judgments in Keller.
Page? Page.
Keller. It's the first, if I can take you to 2114. This was a design right case, which again, the primary tortfeasor could be liable without negligence. It was a strict liability tort in design rights. I think it's in 2114. And then, first of all, there's the judgment of Mr. Justice Emmett, which is at 2125, paragraph 87.
Sorry,
2125.
2125, thank you.
2125, paragraph 87. Perhaps I can just, yes, you can pick it up at 2125. Paragraph 87. Could I just ask you to look at paragraphs 87 and 88? And in particular, paragraph 88, which speaks for itself. That, we say, is the correct test. It's important to note from paragraph 87 that Mr. Keller had personal knowledge of the designs and of the various facts. So this is a case where he knows what the position is, but he's been held not liable because he's acting properly in the interest of the company.
Was there any dispute about the test? Because it appears that the first instance judge applied the test, but incorrectly.
Well, there was a dispute about the test. I'm about to come to the next judgment.
Okay.
Certainly, as I understand it, that's the, and my lords, this is a test which has been applied in other cases in Australia as well beforehand. The judgment of Besanko J is at 2128. Begins at 2128, I believe. And you can see it begins at 266. The liability of Messrs. Keller and Armstrong is joint tortfeasors. My lords, you needn't concern yourself with Mr. Armstrong because he wasn't much involved in any event. But the relevant passage, as far as in Mr. Justice Besanko's judgment, is at paragraph 272 to 273. He comes to the opposite conclusion.
So what page number is that?
My lord, 2129, paragraphs 272 to 273. If I can just ask you to read those to yourselves. And that's, so he discusses the two different tests in those passages, and then if I can show you, when you've had a chance to read that, which way he comes down.
Excitement is too much, Mr. Knox.
I know. 2135, 292. And forgive me. And you'll see what he says. Both Wren and Olsen were effectively two-person companies. That's basically Keller and Armstrong. It seems to me that either test, the primary judge was right to conclude that Keller was a tortfeasor. He was aware of the
paragraph
designs.
are we at?
292.
292, yeah.
Yeah. Basically, he says he was aware of the designs. Now, my lord, obviously, this is a different case here. Responsible for the design. He was directly involved in manufacture, driving force, and so forth. But in particular, there he was aware of the designs. Now, it's fair to say in our case, my clients were aware of the claim to the trademark, but they did have the OHIM decision on their side saying there's no risk of confusion. So there is that difference. But anyway, that's Mr. Justice Besanko's decision. Now, you then go to Mr. Justice Jessop's decision, which begins at 2138. And what he does, and my lords, there's no way I can possibly, as it were, say everything that he says. It's a long analysis going right back to the beginning. And in my submission, it is, although it's quite a long read, it is a well-reasoned judgment. And he comes to the right conclusion. If I can just give you the highlights before going to the conclusion, just with a reference. First, he says, as I do, that Lord Justice Atkin misunderstood what Lord Buckmaster says, page 2144, near the end. Second, he agrees that Mentmore was correct because the directors in Mentmore were not using the company as a vehicle for their own wrong. That's 2147, para 379.
Paragraph.
369. 2147, para 369. Next, he considers three Australian cases which have come to the same conclusion as he favoured. In other words, the same as Mr. Justice Emmett, the first judgment I showed you. The reference for that is 2147, page 370, to 2152, page 381. He next considers another Australian case, a copyright case, in which the judge preferred the strict test. And that's at 2152, 3. At paragraph next at 2156 to 391 to 2160 to 398.
Sorry, I'm sorry. 2156 to
2156 para 391 to 2160 para 398. He discusses Charlie Records and he makes similar criticisms of it as we do in our written case. And in particular, he draws attention to the artificiality of the distinction between protecting a director who's acting in his constitutional role as such and protecting and not giving anyone else any other protection at all. He says, well, that doesn't seem to make much sense, but also it gives rise to problems in practice. Next, at 2162, 403, he points out the oddity that directors who are carrying on the business for the shareholders are on the Atkin LJ test exposed to liability, for decisions made in good faith and so forth, whereas the shareholders are not. And then, importantly, at para 404, 2162, he adopts the point that there can be no common design if the directors are acting in accordance with their duty to the company, and he goes on to agree with Mr. Justice Norse's decision in White Horse. That's 2163, para 405. And he then says that the logical conclusion of Lord Justice Chadwick's decision in Charlie Records saying directors should have protection in certain cases is that there should be protection for any activity properly undertaken as such, and that the same should apply to employees. And that is at 2163, at 406 to 407, which we recite in our case at paragraph 121. And what his essential point is this: if the director is acting in accordance with his duties to the company and properly and so forth, then there is no jointness in the enterprise. There is just one single actor, namely the company. That is that. And so the whole common enterprise doctrine, or joint enterprise, or common design doctrine falls away. That is the essence of his analysis. And I respect it. And in that, he follows the analysis which was adopted in the procuring breach of contract cases, the one that you saw in Arthur Butcher, but also the one that the High Court of Australia had adopted in 1942 in the case called Dawson and Bryan about Mr. Doyle. He says that's why. So that's his analysis, and I respectfully submit that is the correct analysis in this case. And his reasoning makes more sense than the alternative reasoning, which exposes all directors and employees who participate quite unintentionally, in the sense of not realising this is what they're doing, in landing up with a liability which they had no idea they were going to land up with when they're acting properly in the execution of their duties to the limited liability company. And I also submit he is right when he says one thing doesn't make sense is to say that directors acting in their constitutional role are protected, but then no one else is, or seems to be. That I submit is just difficult to fathom how that can be right. And I respectfully submit, you would have seen from our written case, that when Lord Justice Chadwick said what he said in MCA and Charlie Records, he was not intending to limit the protection to that. That was simply an example of where there would normally be protection. But he wasn't saying that's the only time you will get protection. Whereas in this case, the Court of Appeal held broadly that the protection applies only when you are acting in your constitutional capacity, voting, let's say, at a board meeting, and maybe sometimes otherwise, but basically it's only a narrow protection, to which we say, why? And also, where do you draw the line with this narrow protection? And what is the point of this narrow protection if it doesn't avail anyone else in the company? So, those are my submissions on common design. My Lord, burden of proof, I've already referred you to Arthur Butcher. You'll remember the passage where I said the burden is on the person alleging that the company director has gone outside his duties in relation to procuring breach of contract. I say the same must apply here if I'm right on the law. That is to say, the law requires proof that a director acted in breach of his duties to the company and so forth. That also is was a decision of the Court of Appeal in a case called Holding Oil, which we refer to in our case. I don't propose to take you to it, but it's an E1368 and the relevant passage begins at 1395, but in particular, the relevant passages are at 1396 to 97. I say it must be right. If I'm right about the legal test requiring some proof of fault, then it must be for the claimant, if they're suing a director as such, to allege that fault. Thirdly, my lords, this is not in our written case, but something we discovered late last week. The point about burden of proof is the established position in Canada. There's a case called Love Down Hole, which is in our supplementary bundle at page 89. Begins at 89, and the relevant passage is at 91 at 8 to 10. In short, that was an amendment application and the judge refused the amendment because the amendment to bring it as to beef up a claim against the director, but she said, well, you haven't properly pleaded the necessary minimal ingredients.
And that case is called?
It's called, I think, NOV, N-O-V, and I think it's downhole, and then it's at page 89, as I have it in my note,
Of the supplement?
of the supplementary bundle.
Yes.
My Lords, that concludes my submissions on the first ground of appeal. What we say in relation to the second ground of appeal and third ground of appeal, we set it out in our case. I don't have much to add to that. It begins, I'm looking from the key bundle here, page 46, at paragraph 132, or in the E bundle, it begins at 186, at para 132. But essentially, we do say the Court of Appeal went wrong, and they applied the wrong test for imposing a liability to account in the first place. And that, if your Lordships will take it from me, perhaps you want to look at the Court of Appeal's judgment on this point, at 356, paragraph 61, the Court of Appeal said that there has to be something unconscionable, or there has to be unconscionable improper conduct, as has been held in previous cases, if an account is to be ordered. Well, that's our point. Then the Court of Appeal went on to hold that improper is wider than the unconscionable, such that, and I quote from the Court of Appeal's judgment in para 61, such that, quote, the acts which render the defendant liable are themselves improper conduct. Now, in my respectful submission, that deprives the proposition of all content, because obviously you won't be liable in the first place if there's been no, in that sense, if there's been no improper conduct. I submit the general doctrine is there has to be something over and above the mere fact you might innocently have committed the tort. There has to be something over and above that. So the Court of Appeal in my submission went wrong in saying that, and improper in my submission does mean something like, it might mean bad faith, carelessness, recklessness, but some sort of blame can properly be attributed to the infringer, or in this case, the accessory infringer. I say a fortiori. We also say that it's not entirely consistent with famous judgment in Colbeam and Palmer, of Mr. Justice Winder, which we quote at page 47, or paragraph 132 of our case. The general principle is that you're made to account for your profits because to strip you of your wrongfully gained, dishonestly gained gains. Now, my Lord, I accept that's not the only reason why, but there could be two reasons why you would order an account of profits. There would be that one, you knew jolly well what you were doing was wrong, or you were reckless and so forth. The other one would be that you may have acted innocently or whatever, but you're still unjustly enriched by holding on to this money. One could see a case where, let's say, an innocent infringer, let's say for the sake of example, has made £1 million, but he hasn't yet spent that £1 million, he's still got it, and he had no idea, but it's all quite quick. You might say in those circumstances, it would be proper to make an order against him because it's not too harsh on him. But it's a very different position in my submission, where what's happened is you have effectively received this money in innocence over 6 or 7 years. You've treated it as your normal salary, and you have no reason to suppose there's anything wrong with it. That, in my submission, is a very different proposition indeed. And that's why I say, and there's no doubt about it, and it appears in my Lord Kitchen's judgments, one of the reasons why you can refuse an account is precisely when the infringer was, quote, entirely innocent. Now, I do respectfully submit, if in this type of case a claimant wished, or the lifestyle wished to assert, in the face of our witness statements, that we were not entirely innocent, that was for them to do so. True it is, my clients knew about the opposition, Lifestyle's opposition to their application to register the mark in 2012. They knew about that. However, that opposition failed. And after that, and the judgment of over him was quite clear. There's simply no risk of confusion. We don't have to look at anything else. Now, and my client's evidence was simply, well, I've lied on that. My submission is this: an account would probably have been ordered if Lifestyle had challenged that evidence and said, I don't believe you, and the judge had said, yeah, I don't believe that either. But that didn't happen. And so I submit it's quite unfair that they should be treated as somehow guilty.
But is this a principle which is applicable only in infringement cases? I see you refer to Mr. Justice Henry Carr in the Wyeth case.
Yes.
Because, I mean, what you're putting forward doesn't, I think, apply in trust cases. So, for example, a case like Keach and Sanford, where the trustee could not make the profit, the trust could not make the profit.
Right.
The trustee will nonetheless be accountable for the profit. And then there's Phipps and Boardman, where the trustees acted entirely innocently.
Yes. Well, I agree with that. That is because the trustees know they're trustees.
Yes, but they didn't act improperly in any sense.
Oh, no, well...
they acted as it happens in breach
yes.
of trust.
Well,
but
I accept that, but certainly as I understand, the doctrine is slightly different in an account of profits common law for infringement.
Well, these aren't common law accounts of profits, neither your case nor the trust cases.
No, well, it's an account for a tort.
Yes, but it's still, yes. I mean, it's not a common law account of profits,
no.
which really fell into disuse. It's an equitable account.
Well, my lords, I accept that, but it is also undoubtedly the case. But there are differences. The trustee will know that he's a trustee, and there's a strict rule imposed upon trustees to make sure they comply with their obligations as such. That is the
We should be looking at the policy in intellectual property, I would have thought, shouldn't we, not trusts?
Sorry?
We should be looking at what the policy is in intellectual property law, and isn't it not, at least arguably, that the fruits of somebody's intellect, the policy of the law is that the fruits of somebody's intellectual property should be given to them and not by somebody else.
Absolutely.
And therefore, I'm not sure that the state of mind of that somebody else comes into it.
Well, in my respectful submission, it does. On the authorities, it does, first of all. And I respectfully submit it rightly does so. Because otherwise what happens is you have people who entirely innocently make profits, and then they distribute them or whatever. They or make a salary. And they're held liable. In my submission, that is harsh.
Well, it depends how far we want to discourage people from exploiting somebody else's intellectual property.
But it also depends on common humanity, if I may say, and common law. The law...
not really. If you're just taking away profits that somebody's made, you're not making them worse off.
Yes, well...
than they would have been if they hadn't engaged in the infringing activity.
Well, my lord, I accept that. That's why I said the other principle is unjust enrichment. I do accept that.
I mean, this is a common principle, actually. I don't think there is a difference between using somebody else's property, in this case intellectual property, and a trustee using the trust property. I mean, there are all cases in which the trustee, or in this case the infringer, if that's what your clients are made accountable for profits which they have earned by the use of property belonging to or opportunities available to another person.
Yes, I accept that.
I think it's this introduction of some sort of guilt on the part of the defendant as a precondition for the ordering of an account, which I'm finding slightly odd at the moment.
Can I just confirm? I accept that there are 2 points, if you like. I accept that if, and I should have made clear, if, let's say, I've acted innocently, but I've still got a large sum of money, a large profit in my hand, let's say, and I've not distributed it, I've not wasted it, it's still sitting in my bank account, I can easily say, it might be said, that I'm unjustly enriched by being able to hold on to the money, now that it's been pointed out to me where this money came from. I do understand that. In other words, the principle of unjust enrichment would apply. The difficulty here is we don't have that. We've got a rather different position. We've got an account of profits. I now move, as it were, to the third ground in relation to salary.
Yes.
Right. And my lord, this is not, the finding by the judge was not that the monies received were dividends or disguised profits or anything like that. This was simply salary, which was earned over 7 or 8 years. And there was no attack, so to speak, on that salary in cross-examination.
And you say, is this right, that, well, your clients gave value for that?
Yes, exactly.
They worked for the money?
Yes.
So that's your point there?
That's our point. It's as simple as that. So perhaps I should have. I begin to think I should have started my third point first. And anyway, but it's an easy point, but they gave value for that. That's the first point. So it can't properly be said to be profit unless the claimants were able to say, look, come on, you didn't really provide value for that 10% or whatever it is that we've been stripped of. To which our answer is, well, we were busy earning it away. We do have the figures. I think it's on page 701 for what the salaries were. And in Mr. Ahmed's case, they were pretty well constant for all the relevant part of the period of infringement. Miss Ahmed's, they tended to move around a bit. But it's on page 701. And no doubt you'll see that later in the other context of the claim. But that, in my submission, that's one answer. The other answer is, supposing you do treat the infringer in the same position as the trustee, as it were, the innocent trustee or what have you. Well, of course, it's well established from Phipps and Bourbon, I think there's another case, O'Sullivan and so forth, which is in the bundle, that you can give an allowance for the labour. You don't just say, I'm going to take all the money you received.
But was this argued before the judge at first instance? Was he invited, or was the Court of Appeal invited to make an allowance?
The Court of Appeal definitely was.
And they said no?
They said no.
I mean, this is very fact-sensitive, isn't it? I mean, if one's getting to the point of saying whether or not an allowance should be made for labour, the principle is well established. The point is should it be awarded on the facts of this case?
I think all I can say is, of course, the Ahmeds represented themselves in person.
Yes.
They certainly disputed that they should be handing over any part of their salary.
I'm just wondering whether how is this court to approach that sort of issue?
Well, in my submission, the short answer is the allowance should, on the face of it, be, when you're talking about salary, and bona fide salary, should be the same amount as the salary received. But it certainly shouldn't be nothing.
What should it be?
Sorry?
If it certainly shouldn't be nothing, what should it be?
Well, you had my first answer, my lord. It should be the sum received. I mean, in other words, labour was provided. No suggestion that labour being provided at an inflated rate. No suggestion of disguised dividend, and so forth. So I say, well, that's that.
And it's an additional complication. You say why an account of profit's just not an appropriate remedy at all.
Yes.
Subject to whether these points were taken below.
They're certainly taking the Court of Appeal.
Yes.
And, my lord, I'm pretty sure, in fact, my learned, I do remember this from the evidence, and I think the hearing in the first instance, Ahmed certainly did say an account of profits in relation to salary was non-appropriate. And it was pleaded as well. I mean, the pleading is saying, well, how can you have an account of profit for salary? So the point was there, and so I submit it was certainly one where Mr. Judge had dealt with at the time, and in my respectful submission should have done. Because there is a hardship in this case if my clients, on the face of it, haven't done anything wrong, except that have the misfortune to cause their company to commit a tort of strict liability, they find themselves in enormous trouble.
Well, Mr. Knox, we've taken up some of your time by our questions, but I think if you're going to address us any further in relation to these points, then you might want to use up some of your time in reply.
Could I just ask one question, if possible, and that is, the meant more test.
Yes.
You then say that the Australian courts haven't spoken with one voice.
Yes.
I would be very interested to know exactly what the test is that you seek to apply. Because meant more speaks about deliberate, willful, knowing pursuit of a course of conduct or reflected an indifference to the risk of it.
Yes, the test I would apply is the one which Mr. Justice Norse applied in the White Horse Distillery case. That is what I say the test should be. Mr. Justice Norse does point out that there appears to be some sort of uncertainty in precisely what Mr. Justice Ledame was saying, the Memore test. As far as the Australian cases are concerned, they put the test slightly differently, but I will deal with this in reply, if I may, because my learned friend says that they don't. I say they all basically come down on the side of the Memore White Horse Distillery test. Not all, except that, but that's undoubtedly the weight of opinion there. I'm sorry, I know I've overstepped.
No apology called for. Thank you, Mr. Knox.
Thank you.
Secretary.
As of course my learned friend introduced, I'm going to be addressing you in response to his appeal first, and then after that I'll advance my appeal. Just so you know the voices you're going to hear, I'm going to deal with ground 1 and ground 3 of my learned friend's appeal. Mr. Brown will deal with ground 2, and then when it comes to advancing my appeal, I'll advance ground 1, Mr. Brown grounds 2 and 3. Yes. My lords, you'll be very familiar by now with the basis of ground 1 of my learned friend's appeal. It's an allegation that the judge below and the Court of Appeal were wrong to find the Ahmeds jointly and severally liable for the acts of infringement that had been determined in a previous judgment to have taken place. The basis on which the judge found liability for the Ahmeds was, in my submission, entirely conventional. He based his judgment on the decision of this court in the Fish and Sea Shepherd case, and then also alternatively on the CBS and Amstrad decision of the House of Lords. Both of those, in my submission, are standard approaches to the determination of joint liability. I don't understand that there's any dispute that those tests are inapplicable or in some way the judge got them wrong, save for the suggestions that my learned friend makes that the position of the Ahmeds as directors leads to special treatment that they ought to be subject to. Now, in my submission, there is a simple and principled answer to this ground of appeal, and that is that joint liability is to be tested and only tested by reference to the tests in those cases. Everything else is a question of fact to be determined in the circumstances of any particular case. So there should be no special immunity for anyone, director or otherwise, but likewise there's no presumption of liability of any nature for people, directors or otherwise. And in my submission, my lords, that certainly used to be unquestionably the state of the law in this country up until the time of the Mentmore decision, which received some traction temporarily, at least in Mr. Justice Norse's decision in the White Horse case, before, shortly afterwards, the Court of Appeal in the Sprite Brand case said, no, that's wrong. Now, my lords, that principled answer would involve a small departure from the position of the Court of Appeal in MCA and Charlie, because in MCA and Charlie, Lord Justice Chadwick determined that there was some circumstances in which a director might be treated differently. But of course, it's not necessary in my submission for you to depart from MCA and Charlie. If you follow it, and if you follow it in the way that the Court of Appeal did, then the Ahmeds in this instance are liable. But of course, it seems of your judgment to have to review that case. And as my learned friend says, that case, or at least on one of the basis on which he puts this ground, that case was wrong. And you may be asked to depart from my submission. If it is wrong in favour of the Ahmeds. And in fact, the true position ought to be that company law is completely irrelevant to questions of tortious liability. The directors are treated just as any other agent would be, just as any other person would be. My lords, I don't propose to take you back to the facts that the judge found against the Ahmeds. They're in his judgment at paragraphs 41 to 42, and then for Mr. Ahmed, and for Ms. Ahmed at paragraph 45 and 46 to 47. For your notes, those are on pages 388 to 90 of the electronic bundle. And I'm afraid I don't have references to your key documents bundle. When I can continue tomorrow, I hope I will. Those findings against Mr. Ahmed included the fact that he had given instruction for the design of the logos complained about. He was ultimately the decision maker, and that the judge ultimately concluded that he was the ultimate decision maker, and expressed his finding that he had no doubt that Mr. Ahmed was jointly and severally liable on the basis of the facts that he had found. In respect of Ms. Ahmed, the findings were slightly different. Now, she was held to have, and it was ultimately held that her roles only in connection with one division of Hornby Street, the 11th defendant's business, which operated under the name the House of Brands. That was a division of that company that sold goods directly to on a wholesale basis to retail customers, so to people who would sell them in their shops and so on. And the findings of the judge were that Ms. Ahmed had a very hands-on role. She managed the day-to-day running of that aspect of the business. There was a showroom which she chose the goods to be included for stock. Her decision to display them, and she sold them to customers. Now, in my submission, that is a paradigm case of someone acting in common design or procuring a company to deal with goods if they are the person who engages in the act of sale themselves, the act of offer for sale as well themselves. That's a paradigm case. But as you've observed in the course of discussions with my learned friend, the case was put on the basis of joint liability. There is, however, a point to be made in respect of that distinction, i.e. whether Ms. Ahmed and indeed Mr. Ahmed for the acts he undertook was primarily liable, or whether they were jointly and severally liable, that arises from the proposition that my learned friend makes that the individuals working for a company have to be treated as though they are the company. Now, in my submission, my learned friend can't have it both ways. It's either that the people are primarily liable because there's no distinction between them and the company, or they can't say, well, in the question of primary liability, they are not liable because the company has a separate legal personality, but it can't simultaneously be said, which appears to be one of the bases of my learned friend's submission, that they are also not jointly liable because they act only as the company. In my submission, those two factors must be incompatible. It's one or the other. And I'll develop that submission in more detail.
Canon, what do you say about the point whether an individual who's acting on behalf of the company can be personally liable?
Well, I'd say absolutely they can be personally liable, my lord, yes. It is a standard approach that agents are liable for their own torts. I understand that, but in the particular context of the Trademark Act that we were looking at, my lord, yes.
The suggestion right at the beginning of Mr. Knox's submissions was that it's only the company is the infringer there, not the individual.
Well, in my submission, that's wrong, but it's not a point that what you need to determine on this appeal, because the nature of the case put was joint and several liability.
Well, it might be relevant if when you keep saying joint and several liability, but the question may differ according as to whether it's accessory liability or primary joint liability.
Well, my lord, the basis on which Mr. Knox put the point, which was to say, well, use in the course of trade, that aspect, he suggested that could only be the company that was trading.
Yeah.
In my submission, that's wrong. And in my submission, there is authority that establishes that is wrong. Now, it isn't in the authorities that you have, my lords, but a case at the Court of Justice of the European Union called Arsenal and Reed, which I'm sure my Lord Kitchen will be familiar with. Its paragraph 40 determines that use in the course of trade essentially means use in a commercial context and not in a private matter. So someone who is Ms. Ahmed's activity was in the course of trade. Mr. Ahmed's activity was in the course of trade. It wasn't a private matter.
Putting it more generally, a person who is employed to work in an outlet,
yes,
and who receives the goods, puts them on the market on behalf of the company in accordance with his or her normal duties as a person working in that particular outlet, is your submission that that person would themselves be infringing on their own account, or would they be simply putting into action the acts of the company and the company liable?
So, the way that's put in this case is that that's a paradigm example of joint common design with the company. In my submission, yes, they would be. liable, but that's not a question that you need to determine. In my submission, it's not one you need to determine for the purposes of this case, but in my submission, yes, the person undertakes all of the relevant elements of trademark infringement, so they are using the mark because they are undertaking acts of offer for sale, for example.
But they wouldn't be offering for sale, would they? It's the company that would be offering for sale.
Well, my lord, that's a difficult distinction in my submission. Of course, it's not the person is going to engage in the contract of sale, but they are making an offer in my submission.
Are they? Well, not in a contractual sense, they're not making an offer.
But
or accepting an offer.
In the context of use in the course of trade, the Trademarks Act, they are. But my fallback position is always going to be on this. The way this case is put is joint liability.
Yes.
So that person, even if they are not themselves making the offer, they're certainly procuring a company to make the offer, or they're certainly acting in common design with the company to make that offer, because it's from their mouth that the offer is made.
Yeah, that much I follow. It's the notion that the individual employee is themselves, independently, if you like,
yes,
a tortfeasor. Well, under the statute.
Yes.
That's
so in my submission, my lord, yes, they are.
I see. Right.
But as I say, this case is put on the basis of joint liability.
That's right.
It is, but one of the lines of argument that Mr. Knox advances is that there's position of somebody who's an accessory in the circumstances where they can't be liable personally for committing the tort has a protection that they wouldn't have if they could be personally liable for committing the tort and had, say, committed it jointly with somebody else as principles.
My lord, yes, and those principles are...
Obviously we're going to come to those, but...
Submissions, yes. My lord, another point perhaps just to pick up quickly, because it appeared in the opening parts of my learned friend's address to you, was that my learned friend has perceived an allegation that I think goes wider than the way I've put it. So a reference was made to paragraph 128 of my written reply to this appeal, which, my lord, you can find at page 244 of the electronic bundle, at least. And
sorry, which paragraph again?
It's paragraph 128. And this is in the context of the higher test that my learned friend advances, and my proposition that, well, even if that's right, it doesn't actually say the Ahmeds in this case. Now, the proposition I put was that Mr. Ahmed knew of the trademarks, and therefore, and reasonable perception was that those marks would have been infringed. That, I don't believe, is in dispute. Certainly can't have been in dispute once the trademark opposition had commenced, because the trademarking issue was relied upon in that opposition. So the approach that I take is, I don't think outside the basis that the case has been put below, and it's certainly not outside the factual basis of the case.
Well, he on this assumption, he knew about the registration of the marks alleged to be infringed.
Yes.
But it may well be the case that one honestly believes there's no infringement.
Well, perhaps so.
That you accept is an assumed fact for this purpose?
I don't accept it's an assumed fact that he honestly knew, he formed the honest belief that the trademark wasn't infringing. In my submission, my lord, his subjective knowledge isn't relevant even on the higher tests that my learned friend proposes you adopt, because there's reference to recklessness, for example. So, in my submission, I don't accept that Mr. Ahmed or Ms. Ahmed had an honestly held belief that this trademark wasn't infringing, but I certainly propose that they didn't have a reasonable belief that the trademark wasn't infringing.
But is there any finding below to that effect?
My lord, no, because points weren't made. Well, but there's equally no finding the other way.
No, well, that's the burden of proof point, really.
Quite right, yes.
Yes. So, I mean, I don't think this court can make any finding about what a reasonable person would think.
That's a submission I would urge upon you, yes. Of course, you can't make any findings of fact here. And so it will rest on the conclusions you come to as to the law, and then perhaps the conclusions you come to as to the burden of proof if the law is against me.
Right.
My Lord, I was going to propose to take my submissions in, obviously subject to yourselves, in the following order. I was going to deal with some of the earlier English and Welsh cases on joint liability, particularly Rainham Chemical, which you've been referred to. I was then going to deal with Mentmore and the cases it cites, and then UK cases which follow, English and Welsh cases which follow Mentmore. I was then going to deal with the cases on procuring a breach of contract and the proposition that my learned friend makes that essentially an actor within a company has to be seen to be the company. Then I will deal with the Australian cases, and then the points about the Companies Acts, and then finally with the burden of proof issue. So beginning with Rainham Chemical, my lords, just for your notes, you perhaps have this already by now, but the written submissions on the point are made in my learned friend's written submissions at paragraphs, substantially at paragraphs 101 to 111, which are from page 175 onwards, though it is mentioned in a couple of other paragraphs. And then the response to that in my written reply is in my paragraphs 94 to 100, which is page 234 onwards. From those written cases and also from my learned friend's submissions to you today, my lords, there is a proposition that what Lord Buckmaster said in that case has been misunderstood. And indeed it must be has been misunderstood for a century. And no one before this case, not Lord Justice Atkin shortly afterwards, not Lord Salmon in the Wartat Bank case, and no legal commentator who's been identified, has thought that there was a misapprehension of that decision. I've addressed the basis of this alleged misunderstanding in my written case. I don't intend to take you to what I've said there, but it does, in my submission, it's based on a proposition, which I say is wrong, that when Lord Buckmaster said in one sentence, expressly direct a wrongful thing be done, he meant something different than acts expressly directed in the preceding sentence. And in my submission, there's no merit in that proposition. The statement Lord Buckmaster was making wasn't directed, had no element of knowledge of the wrongfulness of the act, merely that there'd been a direction to do an act which turned out to be wrongful. There is a hint, at least in my submissions, in my submission, that my learned friend proposes that when Lord Buckmaster made that statement, that's become very well cited since in Rainham Chemical, that he perhaps was breaking new ground, or that he was raising a proposition which was new to the law and thereafter was misunderstood. Now, in my submission, that isn't correct. Lord Buckmaster certainly wasn't the first person to formulate a test of personal liability of directors in almost precisely the same way. And if I may, I'll take you to some of the preceding cases which also contain the same dictum, essentially. The purpose of doing so is to show the fact that Lord Buckmaster wasn't making the proposition that my learned friend characterises, that there was some need for knowledge of wrongfulness, but merely the act had to be intended, and the act, which turned out to be wrongful, had been procured. If I may, the place to begin is a case shortly before Rainham Chemical, shortly before the House of Lords in Rainham Chemical, I should be clear, which is the Said and Butt case, which you've been referred to in the context of procuring a breach of contract. And that my notes, is the relevant parts at page 4070 of the electronic bundle, and the relevant passage begins right at the end, well, towards the end of the page, 7 lines from the bottom of 4070. So this extract, it's the passage that begins "Nothing I have to say today." And perhaps if I could just ask you, Miles, to just read quickly that.
Sorry, which page are we on? So I've got muddled on the page. Can you give it to me?
Apologies, Miles. It's 4070. 4070.
Yes, okay, thank you.
And at the bottom of that page...
Nothing I've said today is, I hope, inconsistent. Is that the passage?
Yeah, Miles, yes.
Yeah.
Where are we? Yes. Oh, yes.
Just to the end of that paragraph at the beginning of the following page. Now, that particular statement by Mr. Justice McCarty followed his analysis of the tort of procuring breach of contract and his decision there that gave rise to cases such as ultimately Arthur Petra, which my learned friend referred you to, in which there has been an approach by the courts that a director or even an employee is not in special circumstances will not be procuring their company to breach a contract. But what's important, and I'll come back to this later in that context, is that Mr. Justice McCarty was quite clear that that principle did not apply to other torts. But what he records here is that there was already a principle before the House of Lords, before Lord Buckmaster and the House of Lords and Rain and Chemicals set it out again, that a director or servant who actually takes part in or actually authorises such torts, such as assault, trespass to property, nuisance, or the like, may be liable in damages as a joint participant. No, he didn't set out intellectual property infringements, but that falls within "or the like," and is certainly very like trespass to property. And so in my submission, that general principle that a director is liable for damages as a joint participant if they have taken part in or actually authorised a tort is one of longer standing even than Lord Buckmaster's decision.
Well, yes, I see. Sorry. Well, he's basing this on what the Court of Appeal said in Raynham, isn't he?
My Lord, I don't believe he's basing it on that decision, but he's referring to the fact that incidentally it was recently dealt with in that. But
no doubt why it was in his mind.
Yeah, it certainly was, my Lord, and we'll come to see where it appeared in the Court of Appeal there too. Another case my learned friend cites, but you haven't been taken to yet, is the Mersey Docks case. If I could take you to that, if I may, at page 1866 of the... apologies, that's not the correct page.
1479, I think.
I'm grateful. And within that, it's a rather long decision, but the relevant passage in it, apologies. Yes, apologies. Page 1497. And in broadly the middle of that page, a paragraph begins, "But these cases were decided." And within that extract, there's a passage that begins, "If an action were brought by the owner of goods against the manager of the goods traffic of a railway company for some injury sustained on the line," and then, in my submission, the important part, "it would fail unless it could be shown that the particular acts which occasioned the damage were done by his orders or directions, for the action must be brought either against the principal or agent, the immediate actors in the wrong." And that statement in my submission, and in fact the citation for that 4 in brackets is to a textbook on agency, and so indicates in my submission that at least at this stage in the mid-1800s it was well established that a person can be liable for torts that they have ordered or directed.
So what's he's saying? I mean, at face value, that sentence looks a bit against you.
Well, my lords, it's the particular acts which occasioned the damage were done by his orders or directions.
The action must be brought either against the principal, that's the railway company, presumably.
Yes.
Or against the immediate actors in the wrong. Well, that would be the train driver.
So, my lord, I think that it follows from the structure of the entire structure of that sentence,
yeah,
my lords, that if an action were brought by the owner of goods against the manager, it would fail unless it could be shown that the particular acts which occasioned the damage were done by his directions. And my lords, there are.
Well, that yes, I see.
He's one of the immediate actors of the wrong, is he?
Yes, I see.
In that circumstance, my lords, perhaps so. But in my submission, the indication given there is that if a person orders or directs an act which causes damage, then they are liable for it. I think that there's no other way in my submission of interpreting the unless it could be shown that. So that's the unless part is contrary to the action failing. The action would succeed if it could be shown that the particular acts which occasioned damage were done by his orders or directions. Now, my lords, you noted that Mr. Justice McCarty in the Side and Butt case referred to the Court of Appeal in Raymond Chemical. And in that case, there was, again, discussion on a similar basis. And if I could take you to that case, my lord. So the Court of Appeal decision in that case, my lords, begins at page 2407. The relevant passages in my submission appear in page 2416. This is an extract of the submissions, the arguments, page 2416. Halfway down the page, just below the title of the case in the margin on the left-hand side, it begins a person who, this is a submission made in that case, a person...
I'm sorry, can you give the page reference again?
2416.
Thank you. And just below the case name.
In the margin on the left-hand side, just below that, there's a paragraph that begins, a person who commits a tort may be liable, and one who gives directions for its committal may be liable, but no intermediate person in general authority over him is liable. Now, the citation there is to a case Stone and Cartwright, and that is included in the supplemental bundle, which, if your lordships have, is at page 9 of the supplemental bundle.
you want us to go there?
Yes. My Lord, yes, if you would, please.
Lord Justice Younger didn't seem to think much of that proposition.
Well, I'll come to the proposition that Lord Justice Young was challenging in our submission, my Lord, is the third part of that statement, so not this part. This was it's a very short judgment, as was much the way back when this was decided in 1795. It was a case about a mine. So the owners of a house sued the owners of a mine who they thought had undermined their property. Sorry, alleged they'd sued the owner of a mine. In fact, one sees in the 10th line, when it's referred to, when it appeared at the trial before Lord Kenyon at Stafford, that the colliery belonged to A.M. Ward, an infant, and that the defendant had been appointed agent and manager thereof under the Court of Chancery. So the whole point was that the owners of the property had sued essentially an employee of the mine, alleging that he had caused the mine to undermine his property. The case was dismissed. The judgments are on page 623 of the report, page 10 of the supplemental bundle. And the first three of them deal with a proposition that essentially an intermediate employee can't be made liable for the acts of someone under them. But Mr. Justice Lawrence's decision, which is the final of the four set out there, says if the plaintiffs had given evidence that the defendant had particularly ordered those acts to be done, from whence the damage had ensued, that would have varied the case. But no such evidence being adduced, I think the opinion delivered at the trial was perfectly right. So it's an obiter statement from Mr. Justice Lawrence there, but he was indicating that if there had been evidence that the defendant had ordered the acts that were complained about to be done, then and damage had ensued from the acts that person had ordered, then they could be liable for those acts.
So what was the tort?
Well, I think the tort was trespass. It isn't entirely clear.
There's talk of an injury to the,
yes,
presumably to the property. Committed the trespass.
Possibly in negligence, because there's an allegation they neglected to leave necessary and sufficient pillars to support the building and premises. But it was certainly an action in tort. My Lord, I refer to that case because it's cited in the submission in the Court of Appeal in Rainham Chemical.
The reasoning looks to be concerned with vicarious liability, at least what Lord Kenyon was saying, and
quite
Justice Groves, that the idea is that one can understand the employer may be vicariously liable for something done, but not somebody, not an employee who gives the direction on the employer's behalf.
Well, yes, so, or not even giving direction.
No.
An employer who, in this instance, has employed other people, and those other people do wrong. The intermediate employee isn't vicariously liable, but as Mr. Justice Lawrence indicated, if they themselves are given the direction for the thing that caused the damage, then they would be liable. And that's the principle that in my submission was submitted to the Court of Appeal in Rainham Chemical, where counsel for the appellant suggests that a person who commits a tort may be liable. So I'm back now in the main bundle at page 2416. A person who commits a tort may be liable, and one who gives directions for its committal may be liable. And that's, I believe, from the citation is taken from Mr. Justice Lawrence's short judgment in Stone and Cartwright, but no intermediate person in general authority over him is liable. And it's that aspect that no intermediate person in general authority is liable that Lord Justice Younger questioned. We've seen the Betts and De Vitra case when there is liability for directors who are in an effectively intermediate position. Now, in the judgments in the Court of Appeal in Rainham Chemical, First Lord Sterndale, Master of the Rolls, in our bundles, page 2422, page 502 of the report, and conveniently at the very top of the page, the first full sentence. This is referring to a proposition about the liability of the defendant's directors. Lord Sterndale holds the directors, they are not, in my opinion, in the position of directors whom it is sought to make liable for a negligent act of a servant in the company of which they are directors, but rather in a position analogous to that of directors who have personally authorised the creation of a nuisance by the servant of the company. And he went on to find that they were liable as a consequence. So you must mention that's a clear statement that certainly precedes Lord Buckmaster's. So you must mention that's a clear statement that precedes Lord Buckmaster's dictum, but of the same effect, that a director who is personally authorised a tort can be liable for it.
Why were they not found liable ultimately, the Lords?
They were ultimately found liable.
They were?
My Lords, yes, but it was on a special basis. It was that they were in occupation of the premises,
right,
and they were found liable under the tort of Rylands and Fletcher, which applied
as
to
occupiers
who had brought, unbeknownst to them, a dangerous matter onto the premises, which caused a fire and damaged neighbouring occupants. They were held not to be negligent or to have directed any negligent act, because it seems that no one appreciated that this chemical was in fact dangerous until it exploded.
I see.
In the passage you've just read us here, authorised the creation of a nuisance by a servant of the company. Would that be actionable against the servant of the company personally?
Well, in my submission, it's likely to be as well, Lord, yes.
Right.
Of course, these...
So that would be a vicarious liability case so far as the company is concerned?
The company would be vicariously liable, the servant would be personally liable, the director would not be liable unless they had personally authorised the creation, personally authorised that nuisance in that instance. The other judgment of the Court of Appeal that's relevant to these propositions is Lord Justice Younger's judgment, and the reference to the relevant part of his judgment is page 521 of the report, page 2441 of the bundle. 2441.
2441.
And there's a passage that begins, lastly, it was sought to make them liable as governing directors. And actually, if I could just ask you to read that paragraph that begins, lastly. So in that paragraph, my lords, there's first of all an indication that the directors couldn't be liable primarily for negligence, because there's no allegation of personal negligence or want of care on their part. Lord Justice Younger then went on to deal with the case of Betts and De Vitra, and he held that he thought an explanation of that case, well, first of all, I think he wasn't very impressed by it, so he thought that it was the real dispute was about the liability of the company, so there maybe wasn't much attention to the directors. But he held that it may, however, have turned. So in Betts and De Vitra, which I'll refer to in a second, come to in a second, the directors were held liable for acts of patent infringement conducted by employees of theirs, employees of their company. But it may, however, Lord Justice Younger held, that case may, however, have turned upon those directors' personal intervention in respect of the matters complained of. There's then a passage, the separate position was not raised in the House of Lords. The decision on the point below has not found its way into the textbook, establishing any general principle. But he concludes, while that principle as to the position of directors in relation to a company is, I think, so well settled as to be beyond dispute, it's not 100% clear what Lord Justice Younger is referring to in that instance, but in my submission it must, by the position in respect of directors is so well settled as to be beyond dispute, but in my submission it must refer back to his belief that the case turned upon the personal intervention of those directors in the acts complained of in the Betts and DeVitra case. If I may, my Lord, I'll then take you to Betts and DeVitra so I can hopefully make that good. The relevant part of that case begins at page 2456 of the bundle. So the report has a decision about the liability of a different defendant in a linked action, and then Betts and DeVitra, towards the bottom of the page, commences with Lord Chelmsford, the Lord Chancellor's judgment.
Sorry, could you just give me that page again, please?
Of course, my Lord. So it's page 2456.
Thank you.
Now, the case was about infringement of a patent. The patent was, as it turns out, it was for metal capsules covering corks. It was perhaps an important part of commerce at the time because the Betts patent is in a number of cases. It was litigated around the time. But it was specifically limited both as to the material and to the mode of manufacture. So the patent could only be infringed if the way in which these particular capsules for covering corks were made was adopted. In respect of the decision about the directors, they had suggested that they had instructed their employees not to undertake, not to manufacture these capsules in the way that the patented method controlled. And in dealing with that, Lord Chelmsford said, now, I'm reading now from the 10th line of page 442, sorry, the 9th line, in fact, now I will assume, it's halfway through the 9th line, now I will assume that the orders not to work in a particular manner were given, and that the disobedience to those orders was secret. And he says there, although the evidence hardly warrants this conclusion, but that was the presumption on which he was giving his judgment. But granting all this to be the case, I should still hold that the directors would be liable. And then he concludes in the end of that same paragraph, the final sentence, that, of course, he's referring here to injury to a third person, that, of course, must be avoided, whether orders to that effect are given or not. But the directors were bound to take care that their orders were obeyed, and if there was a violation of them, whether openly or secretly, they are liable for the consequences. In my submission and following the way that Lord Justice Younger treated that case, the directors were liable because they had given orders to make the capsules that covered the corks on the assumption, which Lord Chelmsford made, they had also given instructions not to make those corks, capsules for corks, in a way that would have infringed the claimant's patent, but yet they were still liable because they had given the instructions to do the thing. So it didn't matter. So the two principles are, in my submission, if one instructs a person to do a thing which turns out to be, in this case, a patent infringement or otherwise tortious, one is liable for it.
This is the director's own personal liability, is that right? Or the company's liability?
So in this instance, the directors themselves. So the company was definitely liable because it was vicariously liable for the act of infringement, and that's clear from the very first line of this part of the judgment. Not very first line, very first sentence. But the issue there is about the liability of the directors. They'd given instructions to make a thing. The making of that thing turned out to be infringing. They were liable, despite the fact that they'd in fact given instructions which weren't followed, not to infringe the patent. Now, those cases in my submission show that the principle that Lord Buckmaster in Rainham Chemical set out was one that was previously in existence. It wasn't new to the law and didn't require any mental element. And that was, in my submission, unsurprisingly, precisely how Lord Justice Atkin, as he then was, interpreted it in the PRS and Cyril case, which you've already
It's a very odd case, this, isn't it?
I beg your pardon, Mark?
It's a very odd case, Betts v. Vitra. He says that he can't help observing that the general orders issued to avoid infringing Betts's patent show that the directors knew that they were running very near it in their ordinary operations, which rendered additional caution on their part necessary. And then he says, well, I'll assume that the orders not to work in a particular manner were given. The disobedience was secret. I mean, not to work, presumably not to do certain things which would infringe the patent.
Yes.
Now, why? I mean, at the moment, I don't understand why, nonetheless, the directors are liable.
Well, in my submission, the principle on which they're liable is that they're directed the making of a thing. They're directed the doing of an act, which turned out to be infringement of the patent. The statement that Lord Chelmsford makes there about their knowledge that they were sailing close to the wind, essentially, is simply a statement of the practical realities of the situation that faced those directors, not a statement of the legal test which needs to be applied to determine whether they were liable or not. So they needed to be very careful to make sure that infringement didn't arise, because if they didn't and infringement did arise, they were going to be liable for it because they directed the act to be, they directed the relevant act, the making of the things to be done.
What would infringe the patent here?
Well, I can show you that.
I mean, is it manufacturing or is it selling the manufactured goods?
It would be both.
It would be both.
But the particular instance is manufacturing, and the
This is very curious.
But whose liability was at stake? Was it the companies only, or was it the directors as well?
the directors and the company.
They were both sued.
Yes, but in this judgment, it's only dealing with the directors.
Where?
This is just dealing with the director's liability.
My Lord, yes.
Is the preceding case Betts and Nielsen? Is that the
Yes, I think the situation is Betts and Nielsen is it was a parallel decision. The same claimant suing a different defendant who was also alleged to be infringing, and that case deals with many arguments about the validity of the patent and its infringement and so on. So you see at the bottom of page 2456, my Lord, at the introduction to this aspect of the judgment of Betts and de Vitra, we have Lord Chelmsford said that the questions raised in this case as to the validity of patent were precisely the same as in Betts and Nielsen. But as to the infringement, two other defences have been set up. First, the processes used by the defendants were not an infringement of the plaintiff's patent, as to which his lordship thought on the evidence they were. And secondly, that any infringement which might have taken place was contrary to the express orders of the directors, for which, therefore, they could not be answerable. However, the question might be, for which they could not be answerable. However, the question might be determined as to the company.
Right.
So the company was liable, but there was a separate question here about the personal liability of the directors.
Yes, I mean, if we go back to page, we've got the head note is at page 2444.
Yes.
And you're right, at 2445 it said that in the second suit, the defense. Anyway, it said that the second against a company and its director.
Yes, well, and you see on 2445, right at the beginning, the plaintiff was the owner of the patent for making metallic capsules of lead and tin for covering corks.
Yes,
and then it's the following page indicates that the manufacturing mode isn't so relevant. But, my Lord, so
it's a rather unusual proposition that a master is responsible for all the acts of his servants which are done in the execution of his duty when you're talking about a director.
Yes. So
His analogy with the coachman driving his master's carriage.
Yes.
It's a sort of classic vicarious responsibility, course of employment type of case.
So my Lord, to that extent, one could ask questions about whether that analogy was correct. But in my submission, the principle that was determined, well, as Lord Justice Younger interpreted it, certainly in the Rainham Chemical case, the directors were liable because they had become personally involved in the essentially procurement of the manufacture of things which turned out to be infringing.
Just to rattle on, those who have the control of the working are responsible for the act of their subordinates. Well, the subordinates here will be the subordinates to the company, not to the directors, wouldn't it?
Well, I think it's all going to depend upon the particular facts. But if one is controlling people and you're saying you will go and make this thing, and in doing so it turns out they infringe a patent, then in my submission it's conventional that the person will be liable as a consequence of that. I was referring you to the Performing Rights Society in Cyril case, one my learned friend observed playing the Colonel Bogey March. My learned friend suggests that in that case Lord Justice Atkin misunderstood or misapplied Lord Buckmaster's dictum from Rainham Chemical, but in my submission he did not. I've set that out in my written reply. I think in the interest of time I won't take you to that case now.
Could you give us the electronic references, please?
Of course, yes. So in my, it's the point about PRS and Cyril is taken in my learned friend's written case at page 178 of the electronic bundle onwards. To page 180. In my reply, it's paragraphs 101 to 104, page 237 to 238. And the relevant extract from the judgment is at page 1619.
That's the extract from Performing Rights Society.
And Cyril, which you've seen in a number of the other cases, because it's something of a classic statement. There are obviously a number of cases that followed on from those in my submission applying those principles. One then gets to the Mentmore decision, which adopts some importance in the context of this case, because my learned friends rely on it, and it leads to, in my submission, mistaken paths being followed by courts in different jurisdictions as a consequence. That decision is the first page, but at least in the bundle at 2166.
Sorry,
2166.
Raise your voice a little.
I'm
sorry. 2168.
2166.
Thank you.
So that's just the first page of the case. First note, it's a case of Canada's intermediate Court of Appeal, the Federal Court of Appeal, not of its Supreme Court. It was a decision concerning patent infringement. It was a patent about a retractable ballpoint pen, as it happens, but that's not important particularly. There was a finding of the first instance judge, which you see at the bottom of page 2170, which was in response to an allegation that the plaintiffs had in fact copied moulds of the patentee, which as a matter of law isn't relevant, but might have been relevant to the personal liability of defendants potentially. It was alleged they hadn't copied those moulds. It was alleged they'd copied it. It was found they hadn't copied those moulds, and that has some significance in Justice Ledain's judgment later. The trial judge had rejected a contention that the two directors of the company were liable for infringement, and he had held, one finds this on page 2171, page 200 of the report, that the trial judge had found that the two directors, who were Goldenberg and Berkowitz, had imparted practical business, financial and administrative policies and directives which ultimately resulted in the assembling and selling of some goods that were found to infringe the patents. But this was not enough to make the directors personally liable for the infringement. He then went on to express the test that he was applying. Now, I'd like to take that slightly out of sequence, the nested quote in the judgment of the first instance judge on page 2171 that begins, the intention of an infringer, in my submission, should have been the start and finish of the analysis, but it was recorded, the intention of an infringer is immaterial. Infringement is committed as much in ignorance as with actual intent. Everyone is presumed to have notice of a patent, and therefore a patent may be infringed by one who is ignorant of its existence. But the approach that the first instance judge had taken to the liability of the directors appeared from the paragraph immediately preceding that, and particularly from the penultimate sentence of that paragraph that begins, I add that, 4 lines up from the bottom, I add that I make a distinction between the intention I have referred to in dealing with the liability.
Sorry,
of the
I'm lost.
I'm sorry, my
Where are we? We're on page 2171.
Yes, my lord. 2171.
Oh, I'm with you. Yes, I add that. Yes, I've got it.
I add that. I'm grateful. I make a distinction between the intention I referred to in dealing with the liability of a person as a director and the overall matter of intention in respect of infringement generally. And so he was drawing a distinction between directors and people generally. And the reason for that, although he doesn't express any, the first instance judge didn't express, at least his analysis isn't set out here, he held there must be some evidence of intention or evidence from which a reasonable inference can be drawn that the defendants deliberately or recklessly embarked on a scheme using the company as a vehicle to secure profit or custom which rightfully belong to the plaintiffs. So that first instance judgment was appealed. Justice Ledane sets out the competing propositions on that appeal at the bottom of 2171 and the top of 2172. And they, perhaps, my lords, if I just invite you to read the quoted sections that break across those 2 pages, if I may. So those were the competing propositions. Essentially, is there any knowledge requirement or not? And then Justice Ledane began to deal with this. He says, first said that the trial judge, Justice Collier, the trial judge referred to the applicable law as follows. So he set out PRS, and that concludes with the statement that's often cited, if the directors themselves directed or procured the commission of the act, they would be liable in whatever sense they did so, whether expressly or impliedly. And then noted that the appellants relied on an extract from Halsbury's Laws, which appeared to be taken from that case, because it was to the same effect. And then, after that citation, but without any analysis of it, Justice Ledane went into his analysis, and he begins in a statement I think you've seen from other cases and in the written cases. What is involved here is a very difficult question of policy. And this was what he he considered that there was a balance that needed to be struck between a principle that an incorporated company is separate and distinct from its shareholders, directors and officers, and it's in the interest of commercial purposes served by the incorporated enterprise that they should be, as a general rule, should, as a general rule, enjoy the benefit of limited liability.
Sorry, you're reading from?
The passage just below the quote at the top of page 2173.
Thank you.
He thought that ought to be balanced with the principle that everyone should answer for his tortious acts. Now, as an overarching proposition in my submission, my lords, questions of policy are not ones for the courts strictly to decide. They're questions that legislatures should decide.
That's a bold proposition, I think, isn't it?
Well,
I mean, when the House of Lords decided Donoghue and Stevenson, they were making, in effect, a policy decision. In developing the common law, courts have to have regard, don't they, to the consequences of decisions.
Of course, my lords. But in my submission, policy decisions are generally those for legislatures. But the question of policy in my submission did not and does not, in fact, arise. In fact, there was one other point I wanted to make before I dive into that, which is, in a number of ways, this judgment is internally inconsistent, because at page 2168 at the top, in fact, it's probably best if I ask you to start at the last sentence that begins in the second line from the end of 2167. Justice Ledane recorded. If I could ask you to read the two sentences beginning from while it was alleged that, at the bottom of 2167. So
2167. Where do you want us to read?
The last two lines of 2167.
While it was alleged that he was a director.
My lord, yes, until the end of the sentence in the fifth line of the following page.
Yes.
And the important point there, my lord, is Justice Ledane started his judgment by saying, I do not think that the question of whether or not he was a director is important as far as liability is concerned. What he actually did that matters. In my submission, yes, absolutely right. That's the start and finish of the judgment. And it's very difficult to understand why Justice Ledane then went on to hold that there was a difficult question of policy for him to...
Well, I think he's treating him as a de facto director, isn't he?
Well...
If he's not de jure, then he's de facto. I think that's what he's saying.
Sorry. Yes, so there are 2 points in those sentences. One is there's a proposition about whether it's entirely clear that Mr. Goldberg was a director or not. But he then says it likely he was. But the important point is it doesn't seem that Mr. Justice Ledane, in fact, resolved that question, because he said it doesn't matter whether he's a director or not. All that matters is what he did. And that, in my submission, is correct. And therefore, there isn't any difficult question of policy that, in fact, arises. Now, the reasons for Justice Ledane saying there were difficult questions of policy, returning to page 2173, where he does so, as I've mentioned, were first the legal principle of separate personality of a corporate entity. And that's not a proposition that I dispute. But that is not a reason for any difficulty with tort liability in my submission. His second proposition was that it's in the interests of the commercial purposes served by incorporated enterprise that they should, as a general rule, enjoy the benefit of limited liability afforded by incorporation. And it appears they, in this context of the judgment, was meant to include directors. But the proposition that directors also enjoy the benefit of limited liability in my submission is mistaken. That is another indication where that Mr. Justice Dane went wrong. He's also he then goes on to discuss the balancing of the considerations, and in the paragraph that is incomplete at the bottom of page 2173, he holds that there is a principle. If I could ask you, my lords, just to read that paragraph to the end of the page, from "This is a principle that should apply."
Sorry, we're at the foot of 2173. Yes, thank you.
So he suggests that there is a problem faced in situations of small companies, one or two man companies, and he suggests that they should not be liable merely because they merely because there is a general and necessary greater degree of direct and personal involvement in the management on the part of its shareholders and directors. In my submission, that there isn't a principle that merely because they have a generally necessary greater degree of involvement, they are liable. And so Justice Ledane here was addressing a problem that doesn't exist, which he himself recognised by then setting out what the cases do decide, which is that a director is not liable solely because they're a director, or is not liable because they just give general directions. They only become liable if, in my submission, they've procured a tort or acted in common design to procure a tort. I'm sorry, my lord. That is the principle that he notes from the two cases he cites. So he should have recognised in my submission that the spectre he'd raised about liability of directors of small companies was not one that in fact existed. They, like all other persons, are liable for the acts that they've authorised. But if they've not authorised acts or not undertaken, not engaged in a common design that they're undertaken, then they're not liable for them. The end of that paragraph that's at the top of page 2174 is, in my submission, the ratio of this case. Justice Ledane holds that the necessary implication of the approach in the two cases he cited there, I think, that not only will the particular direction and authorisation required for personal liability not be inferred merely from the fact of a close control of the corporation, but it will not be inferred from the general direction which those in such control must necessarily impart to its affairs. I therefore have no difficulty in concluding that on the facts found, to summarise, the facts found by the judge, that the directors weren't liable.
Where's that? Weren't liable? Where's it? Oh,
sorry, I was
top of the first paragraph.
Sorry. I see.
So that's it for that case.
It was not bad. Well, it was not bad. But then he goes on to the more particular, doesn't he? And it's there's quite a lot more in this judgment.
Oh, there's a lot more. Yes, absolutely. Yes. My proposition was that's where he finishes deciding the case, and then he goes on to say, by the way,
I see.
These are the rest of my principles that I'm now going to discuss.
Right. I see. So you say that everything from what, however, is the kind of participation, that's all obiter from there.
My lord, absolutely, yes.
Sorry.
And more than that, I say that it's wrong and without foundation.
To say, well now, what I am concerned to understand is what the treatment of this case in Canada has been since 1978.
My lord, it is still the law in Canada.
It is?
Yes.
Even though it's obiter?
My lord, yes.
Yes.
And it's been relied on as ratio in other cases in Canada, certainly. There is not, certainly my learned friends haven't cited, and I haven't found any case where it is critically analysed it is cited in a case of the Canadian Supreme Court, but without any apparent dispute that it is a correct principle. So it's
cited in the judgment.
Cited in the judgment, this is the approach we're going to take.
We got that in the bundle.
Well, it's in the supplemental bundle, yes. It's a case called CNAR. Perhaps I should just take you to that briefly. It's in the supplemental bundle. It begins at page 29 of the supplemental bundle, but the application is paragraph. The relevant part of the supplemental bundle begins on page 59. So it's part C of the judgment. You have English in the left-hand column. It deals here with the personal liability of various individuals. They fell into two camps, Mr. Weinberg and Mr. Charest, who were alleged to be personally liable, and in 58, there's a record of what the trial judge found. They were personally liable for the infringement since they deliberately and knowingly engaged in the infringement. That was a fact found at first instance. Paragraph 59, there's an argument that the claimant failed to establish that Mr. Weinberg, on the balance of probabilities, that he and Mr. Charest knowingly engaged in copyright infringement, including a little direct involvement in the creative process. Then at 60, a passage from Mentmore is set out. 61, it's essentially held, well, the trial judge found that they did deliberately, willfully and knowingly engage in the infringement of copyright, therefore they're liable, which is unsurprising in my submission, given those findings from the trial judge, and also unsurprising that there was no argument that Mentmore might be right or wrong, given those findings. And then Mr. Davin, who was the other individual, at paragraph 66, which is on page 62 of the supplemental bundle, is the ultimate conclusion in respect of him. There is no evidence that Davin actively or passively authorised the copying of Robinson's work in this sense. Indeed, the record fails to establish that he even knew or should have known that Sucre was developed by copying Robinson's work. So the individuals in that case fell into two camps, those who were liable on any terms and one who wasn't liable on any terms, and there was no discussion of the principle. So whilst it's been cited, it doesn't, in my submission, take the position any further.
It seems to be accepted as a correct statement of the law in Canada.
It does appear to be, my Lord, yes. Now, there is strong academic criticism of the Mentmore decision.
In Canada? In
Canada, yes. And there is an academic paper that I commend strongly to your Lordships. It's quite a long paper, and I think I'm unlikely to be able to take you through much of it orally, but I'll give you references to various parts of it. Maybe, I see the time, my Lords, it may be best if I give you those references first thing in the morning, so I can condense them so it's convenient for you to do.
Well, you could give us some to read if you want.
Yes.
My Lords, yes, in that case, if I could. So it's
Sorry, it may not be very popular.
No. It is quite long. It's a paper by Professor Flanagan in the Canadian Bar Review. It's in the primary authorities bundle at tab 51, tab 49, apologies. So it begins on page 2193 of the electronic bundle, and in particular, I would suggest that it's sections 1, 3, 5, 6b.
Sorry, just repeat that again.
1, 3, 5, 6b.
Roman capitals. Roman capital 1, 3, 5, 6b, 7, and 8. are all, sorry, and then the conclusions at 9, but the conclusions come from discussions before.
So everything except 2 and 4.
Yeah. My Lords, it does, there's a great deal of analysis of Canadian case law afterwards, but the particular pages of it that I rely on are 4 twos, 2222, 2225, well, I think it's probably best to read, if you are willing to, from page 2222 through to 2230, and then sections 7, 2240 and 8.
What will happen?
224028.
Sorry, my Lord. It's section 7, page 2240.
Yes.
And then section 8. Well, I should just point out, in the course of reading that, Professor Flanagan uses the term intentional torts to mean anything other than negligence. So it's slightly curious, but for strict liability torts, he calls them intentional torts. And that, I mean, you see that on page, he sort of gives a definition of sorts on page 2171 that says, sorry, that's a bad reference, apologies.
So, I mean, there's this article. Is there any other Canadian literature about the Mentmore?
Not that I have.
This article was written quite a long time before the CNAR decision.
That's correct, yes. Yes.
Yeah.
But in my submission, it's...
No, I understand. I mean, because this may have cogent criticisms to make, but as far as Canada is concerned...
Yes, so it from a Canadian perspective, it sets out the error of the Mentmore case. Yeah. It also deals with the proposition that my learned friend makes, that the tort of procuring a breach of contract and the principles that arise from that can be extended to other torts.
Right.
The criticisms which are made weren't picked up in CNAR.
That's correct, my Lord. It wasn't cited, but yes.
And Mr. Knox's alternative method of articulating Mentmore wasn't picked up in CNAR either.
I don't. It seems to have simply been parroted and then applied.
Well, Mr. Quentin, that might be
a convenient moment. Yes.
Point at which to stop. We'll resume tomorrow morning.
I'm grateful.